May it please the court.
How about it?
My name is Samuel Heller, and along with co-counsel David Singer and Matthew Newton, we have the pleasure of representing Michael Martin in this case. Just for the record, both co-counsel and Mr. Martin are present and observing the proceedings today. We are asking that this court reverse the lower court's final judgment and enter judgment in favor of Mr. Martin with respect to count one of plaintiff's operative complaint. I want to break today's argument into really three components, which should incorporate, and obviously with deference to the panel's questions, but those three components are standard of review, not only this court's standard of review, since that seems to be an issue between the parties, as well as the appropriate standard of review of the lower court in considering the formal decisions that it had before it at trial. The second part of the argument is going to be the interplay between public and private restrictions. Much of Appley's argument is based on the assertion that there's an inconsistency in the position taken by Mr. Martin here today, that there is somehow an inconsistency with the arguments between private restrictions in a plat and public restrictions insofar as zoning and land use are concerned. And then the third component is the available remedy to the plaintiffs if they prevail in this appeal and the final judgment is affirmed in any part. And so starting with standard of review, this court reviews permanent injunctions for abuse of discretion when it comes to issues of fact. But in this appeal, where the issues raised before this court is the legal sufficiency of the evidence when applied to the law, that is reviewed de novo. And so in this appeal specifically, we are not challenging any of the underlying factual determinations made by the lower court. We are taking the position that those facts are grossly insufficient and constituted an impermissible de novo review of the formal decisions that were approved by the zoning administrator of the city of Tampa.
Even though, for instance, and remind me at this point, there was a 2017 approval and a 2020. Remind me just very briefly what the difference between the two were, what happened.
Thank you, Your Honor. The 2017 reconfiguration and formal decision is what created the three lots that are at issue today. That is what it was originally
lot four, lot 3, lot 4, and block 5. E and lot 5. Right. Okay. So then it was the 2020 that then took block E and connected it to one of the reconfigured lots.
2017 reconfiguration did reconfigure block E into what is now blocks 2, 3, and 4.
Okay, so now theoretically, and so then what did 2020 do?
That's a good question, Your Honor.
Well, okay, well,
it's not exactly clear that none of the boundary lines of the properties at issue were changed in the 2020 reconfiguration. To my best understanding, really the only
as of 2017, then you've got like 1, 3, 4, and 5 connected to block E. And the idea is to convert block E into a buildable lot.
The idea was to issue a building permit in
no. So, we don't get to the building permit yet. I mean, we're talking about Tampa City Code and what you can do with a lot. And one of the things that code says is no lot can have an interior angle less than 30 degrees. Correct?
That is correct.
So when block E is made a part of the other residential lots, doesn't that in itself violate the Tampa City Code?
Not necessarily, Your Honor. The city has discretion to enforce its code and to enforce its rules in the way that it seems appropriate. With
a limitation. Arbitrary.
As long as it's not arbitrary and capricious.
Correct. So now, What about the notice given to the Babbitts warned them that this lot that does not comply, this reconfiguration to create a lot that does not comply with the city code was going to happen with this application?
Your Honor, the notice was proper. The notice identified that there was going to be a reconfiguration that would create
conforming lots, reconfiguration
lots.
of 3 conforming lots.
Correct.
How are they possibly going to understand from that notice that a block with an interior angle of less than 30 degrees was going to be glommed onto those lots?
Your Honor, the notice is simply that. And the plaintiffs also received a letter that outlined specifically what was being proposed to be done. And from there, it is their responsibility to determine whether or not anything that's underlying the proposed reconfiguration is objectionable or something they want to raise issue to.
All right,
and
from
there,
let's come back to that then. So let's come back to that. You're suggesting that if no one complains, the city can violate its own code?
No, Your Honor. The city cannot take action that is arbitrary and capricious if nobody complains. And so the determination of what is arbitrary or what could have been determined to be arbitrary and capricious is what is at issue before this court, and it's considering how the lower court made its review of these decisions. The angle of the lot lines itself is not necessarily a part of the court's ultimate findings. The court was specific in determining that.
If I recall, there was a reference, maybe I read it in a brief, I thought I read it in the judgment, to the prohibition against an interior angle less than 30 degrees.
That was, I believe, if I recall correctly, Your Honor, that was a challenge that was raised by the Babbitts to the city in one of the various letters that was sent in after they observed the commencement of construction. There may have been a reference in the final judgment, and I can confirm that. Really what the court was focused on was the site visit and the lack of a site visit. And that was
what there was no site visit, correct? I mean,
not in the 2020. There was in the 2017. And again,
so in 2017, the zoning administrator went to the site and could look at that Block E and see. I mean, it's really obvious that the interior angle is less than 30 degrees.
Your Honor, in the 2017 reconfiguration, at the time that the then acting zoning administrator did do a site visit, did do those items, determined that it was appropriate, when approved the formal decision that was submitted. The 2020 did not include a site visit, but again, the 2020 visit did not change the boundary lines of any of the lots. And in that respect, I will simply note that the current version of 2711 has removed the site visit requirement. And so insofar as the site visit itself is concerned, the 2017 did include a site visit, and that was what changed the boundary lines. The 2020 reconfiguration did not. And so again, if we're looking at whether or not the decision is arbitrary and capricious, certainly Mr. Cotton was within his discretion to determine whether or not a site visit was appropriate or required when he is familiar with the neighborhood, as he testified, and there was no change to the lot lines. He did state that he reviewed the entire file, including the zoning administrator at the time's notes with respect to the site visit that took place in the 2017 reconfiguration.
Mr. Heller, may I ask you a question? And this actually, Judge Northcutt asked the question that concerned me. Is it your position, given the fact that there's no dispute that Block E, that interior angle is indeed less than 30 degrees, it does violate the code? Are you taking the position that the city could violate its own code by allowing this?
Your Honor, and I just want to be clear, I recall a reference, as Judge Northcutt mentioned, to an angle of less than 30 degrees. My recollection is, and I don't believe that was a finding made in the final judgment. I could be wrong, but my recollection is that was in a correspondence that was received in evidence.
Well, I will say,
concern-
you know, and I can look at the ordinance here.
I agree that that is what the ordinance says.
But let me come back though. Let me read the language. It says, in no case shall a lot have an interior angle of less than 30 degrees. In no case, not unless the zoning administrator thinks it's appropriate.
Yeah, yes, Your Honor. And so again, we're the question
And
before this
and
court-
I'll say the definition section of the Tampa City Code says the word shall is mandatory. So in no case shall an interior angle be less than 30 degrees.
Understood. And so again, in the consideration of whether something is arbitrary and capricious, I understand the point that the court is making.
I think the judge may have had a point there.
Fast forwarding through what if the final judgment made a finding that the lot angle was less than 30 degrees. And again, I don't believe that it did. I believe I do recall the reference. Again, when we look at what the remedy is to send it back to the city to go through the formal decision process again. Here we have a final judgment that includes a demolition remedy and gives an order to tear down the accessory structure.
If I may, Mr. Heller, I mean, this is not the first time this case came up on appeal. I was actually on the panel when it came in on a temporary injunction. So there was a temporary injunction at that point. So it's almost like demolition seems like an extraordinary, act. But your client was well put under notice that there was an issue with this. And it sounded like he decided to still go forward. So he had an opportunity not to proceed with that. So I just want to make sure that, the fact of demolition, he was under notice. This is not the first go around with this. How does that play in your position?
Thank you, Judge Kazam. That actually raises two separate points. The first is the Babbitt's argument that the law of the case doctrine applies to this case, and specifically the prior PCA of the lower court's temporary injunction, as well as the remedy portion of the issues that are to be considered by this court, and specifically Pinecrest Lakes versus Scheidel, Acela that we cited in our brief, as well as some of the cases that have been cited by the Babbitts. With regard to whether or not this court's PCA of the temporary injunction is law of the case, it's not. You had a less than full hearing at the temporary injunction phase. You had additional witnesses that were presented.
Well, let me
at
say
final
this, Mr.
hearing.
Heller. When a non-final order gets affirmed on appeal, it becomes an order of the appellate court. That's how law of the case works. And there might be some issues, like for instance, entitlement to the injunction isn't set. It isn't established because the temporary injunction is different from a permanent. But other issues raised in the case, pretty well established.
Your
And
Honor,
this court obviously determined that the trial court had authority and jurisdiction to hear the case, which was one of the issues raised, correct?
yes, Your Honor.
I think, frankly, you're done on that one.
On the jurisdiction issue, yes, Your
On the
Honor.
decision on the merits, the decision on the merits, which is the PCA.
Well, Your Honor, the evaluation that the lower court made in entering the the temporary injunction, I apologize, was in order to determine whether there was a substantial likelihood of success on the merits in order to maintain status quo.
Right, but didn't you argue that the court didn't have authority to hear the case?
Your Honor, and I would agree that's
you argued that, and this court decided the PCA.
Yeah. Yes, and I'm not taking issue with that. With that, insofar as Judge Kazam's question is concerned. Specifically, I think the distinction is that what we're arguing was that the court's what we consider de novo review and consideration of the evidence in reevaluating the formal decision versus an arbitrary and capricious review, again, under City of St. Pete Beach versus Sawa, I think was the jurisdictional argument made at the temporary injunction stage, we're not arguing that the court did not have jurisdiction to consider
All right.
these issues. And
Okay, so let's come back to another point. I mean, I know we've got you off of your outline, but you know, I stood at that podium a long time. I know what that's like.
Yes, Your Honor.
But another provision, and the judge did, I believe, discuss this. Another provision said you can't divide or reconfigure an existing zoning lot or lot of record that is patently inconsistent with existing lot development orientation and historical precedent pattern of parcel configuration in the neighborhood for a radius of 1/4 mile. Now, this neighborhood is fairly standard. The blocks are, you know, two-tiered, right? Two-tiered housing in the blocks. Can't do that with this, correct? I mean, this is unique, is it not?
I would agree that it's unique, Your Honor.
So how is it not patently inconsistent with the existing lot development? And the court found that was the case, did it? I think.
It did, Your Honor. And this is where I don't have a specific substantive answer to that question, because to do so, I've got to put myself in the position of the zoning administrator and make the decision through the lens of the executive that is charged with managing the growth development plans of the city. And so,
but you would
just
acknowledge
like
that that's an executive decision.
correct, which
It's
is
not,
why
it's not quasi-judicial.
Mr.
An
Cotton's
executive power of
review
the city, correct?
was no, it was not it was quasi-judicial in the sense that it was a determination made without a record being developed at a full hearing or adopted by city council. So yes, it is a quasi-judicial decision.
I don't, you know, the
approving-
quasi-judicial, I mean, I don't think it's a quasi-judicial power. Isn't it not strictly an executive power?
Yes, Your Honor.
Except
Yes.
where specified, the city council say has to approve a
Correct.
plat or replat, but otherwise it's an executive decision.
Correct.
So there's no quasi-judicial, you got to review. I mean, the ordinance says you got to go through the administrative process before you file suit, but the city can't prescribe the jurisdiction of the courts, correct?
Correct, Your Honor.
So, okay.
Correct. And so here, what I think was couched as the jurisdictional argument in the first appeal is really what we're focusing this court's attention on in terms of what the lower court's standard of review was. The lower court acknowledged that its role was to determine whether the decision made, the executive decision made in granting the formal decisions was arbitrary and capricious. But in practice, it conducted a de novo review by reconstructing or constructing a record that was never before the zoning administrator and obviously wasn't created through that quasi-judicial process that would have
What I'm saying is,
occurred.
I don't think it's quasi-judicial process. The city can say, oh, you have an opportunity to speak up, but that doesn't make it quasi-judicial.
That's true. Yes, Your Honor. I agree with that.
Okay, so
Yes.
So what the court had was an original lawsuit for injunctive relief and declaratory relief, correct? This wasn't a
It had an original yes, Your Honor.
review of a zoning administrator decision.
It had an original action where it was to determine by
And it said,
declaratory
hey,
and
the city
injunctive
has
relief.
allowed this, the city has approved this, and it is contrary to law. And we
arbitrary
have
under
no,
the
under the arbitrary and capricious standard, however you want to couch it, but that's what it was. This wasn't a judicial review of a quasi-judicial action.
That's correct, Your Honor.
And they said, we have no adequate remedy. And so the other than to remove the structure. That was the allegation.
That was the allegation, yes. And even if the court were to find that the lower court's determination that the decision was arbitrary and capricious, again, when we go back to what that adequate remedy is, the remedy is to send it back to the city.
And why
And
is
that is-
that? Why can't the
Because-
court, hey, the city messed up here. The city violated the law. There's the only remedy that works is to remove the structure. Why does it have to go back to the city? Again, this is not to send back for findings of fact, correct?
Correct, Your Honor.
And this is not an allegation that the city somehow, city somehow didn't give due process other than, your assertion that they had notice and their assertion that they didn't. But it's not a matter of of a quasi judicial proceeding with notice and opportunity to be heard and a record.
No,
You acknowledge
that comes down to a separation of powers issue. And
yeah,
if this was a restrictive
anytime the executive violates the law, doesn't the third branch have an opportunity? Doesn't it have the right to speak up and say you can't do that? Isn't that what how the system works?
Yes. The question I think that Your Honor is posing, though, is whether or not the remedy of demolition is an appropriate step beyond a determination that the executive may have acted outside the scope of his or her authority.
Let me tell you, Mr. Heller, I have used up your rebuttal time, and I'll still give it to you if you want to stop now.
Very well, Your Honor. Thank you.
Okay. Ms. Borland, you're up.
Thank you, Your Honor. May it please the court. My name is Marie Borland, and I represent the appellees, Barbara and Gordon Babbitt. I'd like to just briefly talk about the standard of review. We obviously have a disagreement on that, and counsel has said that it's de novo because there was having to do with the legal sufficiency of the evidence. And we would say, we've spelled out the standard of review in the brief. Permanent injunctive relief is a clear abuse of discretion. A declaratory judgment, unless it's a misapplication of the law or clearly wrong or not supported by competent substantial evidence, should be affirmed. Here, not only is there not an issue with the legal sufficiency of the evidence, but the evidence was overwhelming and uncontroverted, including through the testimony of the appellant's own witnesses, that the city violated the ordinance in allowing the structure to be built. And Your Honor, I don't want to put thoughts and words into your mouth, Your Honor, Judge Northcutt, but you've pretty much made our case on why why the Babbitts established a clear legal right to the relief requested, and which obviously is the key element to granting permanent injunctive relief. Two reasons for that. The plat shows that Block E was never intended to be built, a buildable lot. It was not a residential block. Every one of the witnesses conceded this. Eric Cotton, the zoning administrator who granted the second lot reconfiguration application, admitted that it wasn't, he said, I would guess not, when asked whether he thought it was intended for residential development. He admitted that it didn't.
And we know, and frankly, you can don't go back and find the zoning laws that existed in the 1920s when this plat was created. But even if it was assumed to have been intended as a residential lot under the current code, it would be a non-conforming, correct? I mean,
correct, Your Honor, and that's what.
And there was no suggestion here that this was non-conforming, that it was previously a buildable lot, and now we're going to build on it under a non-conforming status.
No, everybody knew it was not buildable, and
right.
It was deeded in the form that was deeded to Mr. Martin. And this whole process, and again, I don't want to belabor what has already been said in this argument, but Your Honor has identified the ordinances that were violated, and in terms of whether the court determined that it had an interior angle of less than 30 degrees, it did, right in the final judgment. The trial court made findings of fact.
I mean, you can see it on the plat map.
Correct, you can see on the plat map, and these are the facts. I mean, the facts are what they are. Every one of the witnesses said this was not intended to be buildable. That's the clear legal right. The Babbitts established a clear legal right to the relief requested, and that is that this structure not be constructed. They established irreparable harm and a lack of an adequate remedy at law because, as the court knows, this is real property, which is unique. They've lost the use and enjoyment of their property that cannot be remedied by monetary damages. And there's ample testimony in the record from Mrs. Babbitt of, they can't enjoy their property anymore. They can't sell it for what it was worth before this. So, and also the court has recognized that, yes, demolition is a serious remedy. But in this case, Mr. Martin was put on notice at the very beginning before, when the footers, I think that's the only thing that had been laid, that, look, now that we know what you're doing, we're going to challenge this. And they sent him a letter. They let him know back in 2021. He elected to continue building this structure. And as Your Honor said, demolition, while serious, is an appropriate remedy. And in this case, the only remedy when the city has admittedly or indisputably violated its own ordinance. There's nothing more to be done. And we've cited case law, the Scheidel case, the Daniel versus May case from this court. where the court said when, I think in that case, it was an encroachment on a setback that it needed to be removed. So it's just on our end. We obviously take this matter very seriously, but it's a very simple argument. The evidence was put on. I think it's undisputed that this was not an area that could have been built for residential development. They didn't go out and look at the site. Everyone has conceded this. So I'm not sure what more I can say other than just continuing to go through the facts of all the reasons why the structure violates the code and why demolition in this case is a proper remedy. It's a very well-reasoned, very lengthy final judgment. The court obviously took this very seriously. As the court has recognized, this is the second time this case has been before this court. So Mr. Martin certainly has had his due process right to litigate this. And I think we've been through all of the arguments, and I'm very happy to take any questions the court has. I just don't want to repeat what has already been said and what we've said in our briefs and has been said in court this morning.
Okay, hearing none, move on to Mr. Heller's rebuttal.
Thank you. And very briefly, I want to address.
Mr. Heller, can I ask you a question? If
Yes, sir.
your suggestion that this be sent back, what do you envision happening?
We envision one of two scenarios. What we're requesting is that this be sent back with an instruction to enter judgment in favor of Mr. Martin. But the best case scenario for the Babbitts is that it is reversed on the remedy grounds of demolition with an instruction to send back to the zoning administrator to go through the formal decision process again and where Mr. Martin would be able to reapply with respect to the reconfiguration.
Let me ask you this, Mr. Heller. If this court can look at the situation on the ground as represented in the plat, so far, the evidence, and see for itself that this approval violated the law, why would we send it back? Because even if it came back the same way after a submittal, we still have and the court and the lower court ruled the same way. We have right for the wrong reason. We have the tipsy coachman rule. And
Your Honor, again, that is why we're suggesting that if the court does find that there was a violation in the angle, less than 30-degree angle, the only remedy—
Or the inconsistent with the development for a quarter mile.
Well, Your Honor, and that really is something that is within the purview of the zoning administrator. And the
patently inconsistent, the lower court found that this violated that. So it does. I think that kind of takes it out of the zoning administrators.
And that is what we were saying was inappropriate and improper on the part of the lower court in making that determination, because the lower court was not permitted to make that determination.
So if we look at this, if we look at this plat, which we got sent up, is there any other parcel of land on that plat shaped like this? No. The answer is
but at the same time,
is there any other block where the lots are not two-tiered, 90-degree angles and so forth? No.
No, Your Honor. At the same time, the plat is depicting property that includes the alleys that were vacated. And so once you have that alley vacated and the reconfiguration occurs, which subsumes Block E into a portion of lots 3 and 4, then again, this falls under the purview and the discretion of the zoning administrator when it comes to determining what is the development pattern, what is the characteristics of the community that it is allowing this to go through. That is the executive's function.
Okay, so you're saying that where this happens, and it may well be inconsistent with the whole rest of the neighborhood for a quarter of a mile, but because this happened, this is now consistent?
It is up to the executive in determining its development goals and plans for that community to determine what is within those characteristics. And just because there is not another parcel that is this shape doesn't mean that it is inconsistent with the development characteristics. Again, when Your Honor asked me what is my opinion, without that background and without the ability to look through it through the lens of that zoning administrator who's charged with stewarding the development of the community, I can't have that opinion, and that is what was improper on the part of the
wait a
lower.
minute, but you know, you're getting back to, you know, what can a court do other than assess the facts and determine whether the city violated the law? I mean, that's what the court's supposed to do, correct? And so in that respect, theoretically, the court gives due deference to the zoning administrator for whatever the scope of his or her decision is, but not for what the law is.
Correct, Your Honor. But in trying to get to the remedy portion of this, when the court elects to award a demolition and to order a tear down, that is invading that legislative province. And when Ms. Borland raises Daniel versus May, something to note, and there is actually a quotation from this case in the answer brief on page 50 of the answer brief, and I'm sure it was inadvertent, but this was a restrictive covenant case. And there is a reference in the quotation to ordinances and laws, and that is nowhere found in that opinion. And in fact, as we referenced in our reply brief, the relief provided under the Scheidel case was restricted to a challenge brought under 163-3215, which has not been expanded.
Let's come back. You know, I mean, there are some basic differences between restrictive covenants, which are for the most part agreements between private parties that run with the land, correct?
Correct.
As opposed to the law established in the city code.
Correct.
Right. You helped you use your 5 minutes again, Mr. Heller. So your time's up. You should just wrap.
Thank you.
All right. You performed well under fire. And with that, we'll move on to our next case. In order to leave our virtual courtroom, you need to click. Depending on which version of Zoom you have, in the lower right corner, there's a little man going through a door that takes you out into the ether, where it might say leave, and that also takes you to the ether.
Thank you.
Thank you.
Thank you, Your Honor.
Right.